Good morning and welcome. My name is Ellen Forsyth. I work in Public Library Services at the State Library of New South Wales. I would like to acknowledge the traditional custodians of the land that we are meeting on today and pay my respects to their elders past, present and emerging, and to any Indigenous people here today. As well, we acknowledge the contribution that people of many nations have made to this country. 73 people have RSVP'd to this presentation by video conference, although only 28 have managed to get online so far. Questions will be asked by chat, so please mute your microphones and videos. When you have questions, add them to the chat stream and Jessica will answer them at an appropriate time. We are recording this session. So people know which questions Jessica is answering, she will read or paraphrase the question prior to answering it. If you want to tweet or share on social media, please use hashtag NSWPLN2017. There are recent changes to copyright in Australia, hence this session, and we are fortunate to have Jessica Coates to provide an update on the latest in Australian copyright that affects the public libraries, including the Copyright Amendment, Disability Access and Other Measures Bill. Jessica Coates is a copyright and communications policy expert with 15 years of experience working in Australia and overseas. She is the Executive Officer of the Australian Digital Alliance, and she has been the Global Network Manager of Creative Commons. Just a reminder, please mute your microphones, and I will now hand over to Jessica. Thank you.
Hi all. Just checking if people can see the share screen. At least one group is saying that they can't. No, and it seems to say we are sharing now. I hope that everybody can see. Good, excellent. At least some of you can see. I apologise to anybody who can't see, and I hope that it all makes sense. Well, welcome everybody today. It's very exciting to get to talk to you about the most recent copyright amendments. Essentially, as Ellen said, my background is as a copyright lawyer. I've got a law degree, I've got masters, I've worked in the government for years, and I love copyright, and I love copyright for libraries and archives. My role at the ALCC is basically the ALCC brings together most of the large library and archive organisations in Australia, so ALIA, CORL, NASLA and New South Wales Public Libraries Association are all members. And our main role is, we've got two main roles. One is to provide training for our members and for anybody else who wants to turn up on the latest in copyright, etc. And the other is to be an advocate for copyright reform, for a voice for our community in the copyright debates. So I do both of those, and it is very fun, and I love this stuff. I love being a library and archives copyright lawyer. So I'm very happy to try to answer all your questions. The exciting thing about being here today, sorry, that's the ALCC, is that there is something to say. So normally copyright reform can be very, very slow, and normally maybe once a decade you get some kind of changes. But this is that moment. We've just had major changes only a few months ago, and probably more excitingly, they're major changes that focus on our community. They're mainly about the libraries and archives, disability communities, a few others, but really we're one of the major beneficiary groups. So it's really cool to get to talk about what's going on with copyright at the moment. Just as a very quick background to make sure we're all on the same foot, because I'm not going to do a what is copyright type level thing. This one's focused on updates. I just want to, the summary of how copyright works is that copyright covers most of the things that you want to use, pretty much, you know, books, films, audio works, you know, almost everything that you guys as a librarian archive might want to share with your clients or put out, things like that, is likely to be covered by copyright, unless it's extremely old and the copyright has finished. It will also cover most of the things you want to do with that, particularly now in the digital age. You can do things like loan books and put things on display without triggering copyright, but the moment you start copying them or sending them out electronically via email or anything else, even if that copying, oh sorry, it's doing that automatic move forward thing. I'm going to try to stop it from doing that.
Hi, Jessica. We seem to have lost sound.
There you go. Is that better?
Yes.
Ah, there you go. It had muted itself, but I don't know how that happened. Anyway, okay. Anyway, all I was saying is that you're lucky that librarians and archives actually have a lot of exceptions that allow you to use copyright material even without permission, and that's what a lot of these changes are to do with. So that's the copyright overview. The big change is the Disability Access, the Copyright Amendment, Disability Access and Other Measures Act 2017. All very pithy, the title, as per usual. So basically, this legislation comes about because of a thing called the Marrakesh Treaty. A lot of you, I imagine, would already have heard of this. It's been a very big deal, particularly in the library and archives community. And essentially what it is that it's the first international copyright treaty that provides basic rights for users to use copyright. All the main existing treaties that govern copyright at the moment basically focus on the rights of copyright owners, so how you can restrict copyright material. Marrakesh focuses on how you can use copyright material, and it's specifically for people who are blind or visually impaired or print disabled. So it's taken 20 years to get it through. It's been a really big, hard effort for everybody and really big deal. But it's and even though it was just rights for blind people, it still was really hard to get through, but it did eventually get through. And the great news is that Australia was always a really strong advocate for it. So Australia has been one of the countries that's really pushed hard for this to exist and really pushed hard for getting it as good as possible. The Australian government has basically looked at after the Marrakesh Treaty came through, they looked at our laws and they said, actually, all of our laws are already compliant. We don't have to change our laws at all. We didn't necessarily agree with them, but it was okay. Nobody had to get up in arms because the government said, even though we don't have to change our laws, we're going to make sure we're best practice. So basically they said, we're going to improve our laws for people with a disability to access copyright material, which is really great, even though we don't think we have to. It's great that they did. And they said, while we're at it, why don't we throw in a few other amendments at the same time? I have this picture of the public servants who run copyright having a little list in their cubicle that says, things I would like to fix. And they picked the easiest ones of those, the low-hanging fruit. And that's what we were all calling it, the low-hanging fruit bill. So what happened with so basically they were putting in these other the changes for disability, and they decided to put in 4 other major categories of changes. Changes to the educational statutory license, changes to the preservation provisions for us, and changes to the copyright term provisions for everybody. So essentially the bill went through. There was another set of changes in there about safe harbours for providing access to technological access. I'll talk about that in a little bit. They were removed because they ended up to be not so uncontroversial. They were actually difficult to argue, so in the end they took it out. But we ended up with these 4, and the bill passed nice and easily, very, very quickly actually, and they come into force next week on the 22nd of December. So basically for the beginning of next year, we've got the new laws. Mostly, some of them are delayed. I'll talk about that as I go through them. So I'm going to go through each of them in detail now. I'll just see nobody's asked any questions yet. Normally I would pause now and say, any questions? But let's keep going, and we'll maybe do questions mainly at the end. So here's the 4 main provisions, and let's see what they say. So first of all is the accessibility provisions. Essentially, Australia's current law to provide access to people with a print disability involves 2 different exceptions in the Copyright Act. One is a statutory license that allows institutions that work with people with a disability to make certain uses to provide material to them. And the other one is a Section 200AB flexible exception. So that's basically a thing that is broader and lets other people do things, but is a little bit confusing. So both of these are quite confusingly worded and bureaucratic. The statutory license is out of date. It's a free statutory license, which is nice, so you don't have to pay money, but it is still nevertheless quite bureaucratic, and you have to report and things like that. So what the government did to improve these is they replaced them with 2 new exceptions that were similar but better. So one is a flat exception for institutions, people working with institutions. The other is a new fair dealing for providing access for those with a disability. So the institutional exception basically replaces a statutory license, but improves on it by applying to any material. So the statutory license had different rules depending on if you were working with audio-visual material or pictures, music, that kind of thing. Any activity, so copying, communication, adaptation, anything that you're doing with copyright material, this exception applies to. Again, the other one had different rules for different types of things. And probably most importantly, any disability. So not just print or visual disability. So it means not only people who are blind or low vision or who have dyslexia, they were all covered by the previous exceptions. Now people who are deaf can do subtitles. There was no exception in our Copyright Act to allow you to subtitle things before. Or people with autism or other reasons why they might want to, intellectual disability, so they might want to create plain English versions of materials. Those kind of things are all allowed. Even physical disabilities. If you have cerebral palsy and it makes it difficult for you to manipulate a book, then it can be transferred into electronic form so that you can now manipulate it. So it's much broader than our previous exceptions, and it's much broader than the treaty requires. The treaty only requires us to provide access to people with a vision disability. So it's really great of the government to have gone so wide. It also improves on the previous statutory license by getting rid of some complexities and confusions that people had in it. There were formalities about having to register, like you're only supposed to use it if you registered and you were supposed to report on all the copying you were doing. It was quite bureaucratic. It also clarifies confusion around. Some people thought they had to do things like destroy copies. So a university would copy material for a student and then destroy it and then copy the same material for the next student, which of course is obviously massively inefficient. And so the great news is that they got rid of those, they made it clear, and they clearly made it clear that we could import and export material. So that was one of the main purposes of the Marrakesh Treaty, was to allow people to share accessible material. So material that's been converted into an accessible form, like DAISY or EPUB 3 in the UK or the US or Spain. There's some giant repositories of hundreds of thousands of works. And we can now move them back and forth. We can literally just email them to each other to have access to them, as opposed to previously, it was very questionable whether or not it was legal for us to do that. So great news is they fixed it up. There are still some limits in it. One is that you do have to do a commercial availability test before you convert material under this. We don't see that as being a big problem, both because commercial availability, only about 5% of materials are actually available commercially. So 90% of the time, it's not going to be available in the format you need. And secondly, because in fact, if it is available in a reasonable time at ordinary commercial price, it's going to be cheaper to just buy it than to convert it yourself. So most of the time, it works hands in hand. It basically is a good idea to check anyway, because it is quicker and cheaper normally to just purchase it than to actually try to turn it into a format. Another good thing about the commercial availability test and the whole exception is that it's linked very strongly to the exact format and needs of your client. So essentially, if your client needs 32 size font and it's only available in 18 size font, so it's in large font but not large enough for your client, you can still copy it into 32 size font. If your client is an elderly person who wants to listen to the latest John Grisham, they have low vision, then an audiobook might be fine for them, a commercial audiobook. But if they're a student who wants to write an essay on the same book and they need to show pagination and they need to be able to show chapters and quotes and things like that, then an audiobook isn't going to be good enough and you still will have the right to convert it. So it really focuses very strongly on the needs of your client, and if it's available in the form that they need, then you can purchase it, but if not, you can still convert it. So we don't see it as a very big limitation, but it is something to be aware of. You should check if they're available before you convert. The other main limitation is that it's limited to educational institutions or non-profits with a principal function of assisting with those with a disability. I thought at first when I read this that was going to exclude most libraries, but the explanatory memorandum which comes along with the bill, which is the stuff the government puts out to explain what they mean, actually says specifically that most libraries will be covered. So we'll just work on the assumption that, because it doesn't have to be your only principal function, as long as it's something that you do as part of your daily work, or that you see as being a function that you have, then you qualify. So we'll just say as a default setting, we're assuming that libraries qualify because the EM says we do. So that's good news. So basically, this gives you a nice flat exception without any need to think about the fairness or the reasonableness of what you're doing. You can basically do anything that is needed as long as the material isn't commercially available. And there's pretty much no limits other than that. So it's really great, really broad, and nice and simple for people to apply. More importantly, even if it doesn't apply, even if you're not sure if this is broad enough, say you're not a qualified institution or the material is commercially available, you can actually still potentially make the use under the other exception, the fair dealing, which is actually the even broader one. It's really quite amazing that Australia has a fair dealing now for accessibility. I'm not sure that anybody else in the world actually has taken this approach. Fair use is as broad as this, but other than that, we're really lucky. And the good news is that they are complementary, not exclusory. So the fact that you don't qualify for one doesn't stop you from qualifying for the other. So you just have to go and make sure you do. So how does this one work? The fair dealing for accessibility works like pretty much all of the fair dealing provisions in the Copyright Act. It basically says you can do whatever you want as long as it is fair and for the purpose of providing access to somebody with a disability. Actually, that was that slide. There you go. This is an improvement on Section 200AB, the flexible section we had previously, in that the previous one didn't allow commercial uses. It was very confusingly worded. People have always been uncomfortable with using Section 200AB. It uses words like special case that people are worried about, that kind of thing. And most importantly, they've done what they did with the other one, where they've applied it to all the disabilities now. The same definition out of the Disability Discrimination Act. So that's so it's much, much broader than it was previously, and it's much simpler and easier to read. All you have to do is it for the purpose of providing one or more persons with a disability access to copyright material, and is it fair? The fairness test is the only test that's required, but the Act does help you with some indication of things you might think about what is fair. You think about all the circumstances. Anything that you think is relevant can be, it counts. But some of the things that are, obviously relevant is things like, what are you doing? Is it a commercial or non-commercial use? Is it are you copying the whole of work or part of the work? What's the social benefit argument here? Obviously, most of the time, the social benefit's going to be pretty big. Are you just giving it to one person, or are you putting it up on a website? That's maybe going to make it a bit harder to make it fair, but it won't necessarily not be fair. It just depends. The nature of the material, so is it a government fact sheet, in which case almost everything you do will be fair. Honestly, the government can't complain too much. Or is it like the latest novel that's selling out at the bookshops? It's going to be harder to make that fair unless you are, providing it, directly to a person, that kind of thing. And probably one of the main ones, the ones that people are most concerned about most of the time, is the potential market for the work. Is the effect on the potential market. So that means basically, are you undermining a sale or multiple sales for the copyright owner? So just try not to do that as much as possible. And that's where this commercial availability thing comes in. It isn't a test. It doesn't matter if it's commercially available. It doesn't stop you from using this, but it might be relevant here. If it's commercially available in the format you need, then it makes it less likely what you're doing will be fair, unless there's some reason why the person can't access it in that format. That can still be fair in those circumstances. And then there's how much are you using? Are you using all of it or part of it? The good news is that the EM once again makes it clear that you can for accessibility, you can almost always use all of it. It's a bit silly to require people to do chapter by chapter or anything for accessibility. So you can totally copy all as long as that's what the person needs. So really nice and broad, basically. Hopefully, I trust you guys to only try to do fair things, and so I think most of the things you try to do will be fair and will qualify as this. Most importantly, the government, again in the EM, has made it very clear that they do not intend you to be conservative with this. They've said it's supposed to provide equitable access for the person with a disability to a person without a disability. So that would be not a bad place to start in deciding whether or not what you want to do is fair. How can my clients without a disability access this stuff, and how can I make my client with a disability's experience as close to that as possible? And that's really, really great. So don't be conservative, don't be too risk averse. Assume that anything you're doing that sounds reasonable and stuff is probably allowed. It's good news. So as I said, this allows you to do things like commercial projects, import, export. You can build a library of accessible materials. A lot of people were as I said, were deleting them before, but once you've converted them for one person, there is no logical reason why you shouldn't get rid of it. So it's really great, really flexible. There are no formalities or required. Basically, you can just do it. But I have to say it is always a good idea to record your thought process. So you probably want to have something where you've said, we're doing this under this exception, one of whichever of the two you've chosen, and maybe even something saying this is why we think it complies or something like that, with the fairness test, for example. And of course, it is normally going to be, just a reminder, it's normally going to be cheaper and quicker to go with commercial options, so it's always worth checking that out. Me and the disability groups in Australia and some of the other main copyright groups who are representing rights holders and publishers, so some of the people who don't normally work necessarily together, are actually all getting together to help with best practice implementation of this. So there should be a guideline coming out actually in in the next month or so. There should be a guideline coming out that you can have access to, that goes through steps and checklists that you can think about in applying these. For more information, contact people like Vision Australia, etc., who I'm sure you work with anyway, for any clients with disability. Vision Australia, the Australian Blindness Forum, there's the local state ones as well. The guide dogs, of course, are good. So hopefully people will start using this and things will get much better. And the amount of material that our local, the accessible materials that we have in Australia should skyrocket thanks to these. That's the theory anyway. So I'll just pause for a second and check. Does anybody have any questions about this one specifically? Just seeing if, yep, no, I can see I'm up on chat, so it looks like not. So I'll jump forward to the next ones. The educational statutory license. Don't worry, this one is much quicker than the last one. I know I went on about that, but I love the disability exceptions. They're really great. So the educational statutory license, basically what they did with these changes is that they took the exact existing statutory license. Any of you who've ever worked in a school or university will know how very long and complex the two educational statutory licenses are, Part 5A and Part 5B. They were like 30 pages long, very bureaucratic, very old-fashioned. They'd been a little bit updated for the internet, but they still didn't apply the same to different materials and different uses. They required a lot of tracking and that kind of thing, and they were really very clunky. So basically what happened is that the schools and the Copyright Agency who do the statutory license, again, two groups that don't normally work a lot together, they have a commercial relationship, so they aren't necessarily normal collaborators. They got together and they just agreed that they could do a better job than what was in the Act at the moment, and they rewrote it. They actually cut it from about 30 or 40 pages down to about 3. Apparently the government then came along and I think it ended up about 7, so it's not quite as short as they wanted it to be. But what they mainly did is they took out all of the very specific bureaucratic elements, and they just kept the main intent of the provisions, which was that schools and universities can basically copy material like course packs and photocopying in classrooms and display things on smart boards, all those kind of things. They can make all the uses of the copyright material they want to make, and then they have to pay for it. So they have to pay to the Collecting Society. The Collecting Society will collect that money and then pass it on to copyright owners. But they took out almost all the rest of the detail. So some of the things that you guys might be familiar with, like the 10% rule that was in the statutory license and things like that, that 10% rule got taken out. They also added a new flat exception just for online exams to make things, because at the moment you can copy stuff into paper exams but not online exams. So they fixed that, a little bit of fix. So they took all the detail out of the statutory licenses and basically left it as simple as possible. And instead, they are going to negotiate those details in the contracts that they do anyway. So every couple of years, they negotiate a contract that sets the rate. They go to the Copyright Tribunal if they can't agree on amounts. And from now on, that contract is going to include a lot more detail around things like percentages you can copy, record keeping, all those kind of things. They're all going to be included in the contract rather than in the legislation. And that means it can be updated every 2 years to take account of new technologies, to take advantage of efficiencies. Hopefully it'll be much, much better, basically. So it's much more adaptable now. And it's able to keep up with new technologies and be customized. But the main message is actually nothing is changing until they negotiate those contracts again. So they've got new legislation. It should be really, really cool. But until that new legislation, until those new contracts are negotiated, we don't change anything on the ground. So University of Australia will be doing it for the universities. The CAG group, copyright group who run Smart Copying will be doing it for schools, and they will, basically they will be informing people when there's a new contract and how that contract should work, and they basically have very high hopes that it'll be a much better system than we currently have. So that's why this is much quicker, is because it's really great, and it's all happening soon, but not just yet. Probably mid next year will be the earliest that we get the new contracts. Until then, everything stays the same. I'm looking at the photo array. Photocopying. Can students copy more than 10% of a printed work? They can, if that work isn't available in any other, in another way. Basically, if it is a commercially available work, so if it's, a Harry Potter book, they're not supposed to photocopy more than 10% or one chapter. And that's under both the fair dealings and under the statutory license. In fact, if a student was doing it, it'd be under the fair dealing, not under the statutory license. But if it isn't available, if it's work that you just can't buy somewhere else, it's historical work or an outdated textbook from 2 years ago or something, then they can copy as much as they like, as long as it's fair, as long as they're not, copying it to replace a sale, basically is the idea. So there you go. Aha. Any more questions about the statutory license? There's not really much to say yet. Nope. Okay. Well, we move on to preservation and others. There's some other things too in the preservation, which is a bit tricky. Basically, this is the first one that's specifically for us as libraries and archives. In fact, it's the only one that's specifically for us, but really we benefit from all of them to some degree, depending on which institution you're in. So anybody who has tried to work with Australia's current preservation provisions know that they are absolutely crazy and bonkers. They were written a very long time ago, before the digital era. They apply differently depending if you've got audio-visual materials or textual-based materials. They say things like you can preserve audiovisual or published material once it has been lost, stolen, or damaged. So that's really convenient, isn't it? To be able to preserve things once they've been lost or damaged. So what they did, everybody acknowledged they were really not working very well. And in fact, I think most institutions have been basically doing proper preservation and best practice preservation things under Section 200AB, which is the flexible dealing that libraries have, and kind of saying it's allowed by that, rather than actually complying with these provisions. At least if you were trying to comply with those provisions, I salute you. But what they've done is they fixed them. They've almost fixed them entirely. They basically took out all the ridiculousness and the complications, and they replaced them with a nice, simple provision. You can see the basic language there, which says, and that is simple for the Copyright Act, by the way, that's nice and easy, that basically says, if you're a librarian, you can copy stuff in your collection or in the collection of another library, and that's because that's so that you can get people like the National Film and Sound Archives and stuff who have the right equipment to copy your materials if you need to, for the purpose of preserving it. And that's basically it. That's almost the only. That is almost the only requirement. Basically, the only other requirements is that you can do anything you need. There's no limits on the number of copies or formats it can be done into, which the last one did have. No difference for different materials. It's really great. It's really flexible. It's just basically do what best practice said about preservation with your materials. Now, the only significant limitation is there is a commercial availability test for published materials. So basically, if you have, if you're preserving, a commercial book or a commercial product, you are supposed to check whether or not it's available in the format you need for preservation. And now that is very key, which is why even though we don't like this restriction, we ask for it to be removed. We're not too concerned by it because, of course, materials are almost never available in the format that you need. So for preservation, basically, like you don't preserve materials in commercial ebook formats. You don't, you'll be turning them into EPUB 3 or other things like that that are very flexible and that things are rarely sold in. So we don't see this as a very large limitation. We're also very keen to say that you can do sampling to do this. So basically, you don't have to check every single work that you want to preserve, whether it's commercially available. If you've got a category of works that are very similar to each other, say they are very old videos, very old videos that you've had in your collection for a while, you can check for one or two of them, maybe the most obvious ones, and then you can apply the decision that they aren't commercially available across the thing. Also, different editions. So a video will normally be a different edition from DVD. They will have different materials in them. They may even have edits in them. So once again, a commercial DVD doesn't necessarily stop you from doing a video. And the commercial DVD isn't in preservation format, being the most important thing. So the other thing is the EM makes it really clear that you can do point of acquisition preservation. So basically, the moment you purchase something, you can preserve it, even though you've just purchased it and it's commercially available in the format that you've purchased it. Presuming it's not commercially available in the preservation format you want, you can just preserve it straight away. The only other significant limitation is that these new provisions only apply to libraries that are open to the public, while previously the definition of library for preservation was broader. It didn't have that open to the public requirement. Still, archives is the same. You just have to be a non-profit archive. The argument here is that they basically want to start using one definition of library for all the exceptions, and so the other exceptions about document delivery and supply and things like that are limited to libraries that are open to the public, so they've limited this one too. That includes interlibrary loan, so we don't see it again being a big barrier. The main message here is that if you, and it also includes, students or who come in occasionally, or researchers who make appointments. All of that includes being open to the public. So most of you, I'm sure, won't have a problem. If you do feel like you might be closed off, if you're, say, a corporate library, I don't think anybody here is, but a corporate library that only works for employees, start doing interlibrary loans and you'll be fine. You're covered anyway. So there you go. The main question that people ask about these is, how does it provide access? And the key message is that the preservation ones are to do with preserving materials, not providing access to them. But there is actually one bit in them that is about providing on-site access. So that basically allows you to use a preservation copy to show it on a display screen in your on-site for clients who've come in to see stuff, in the same way that you can use the preservation copy for section 49 and 50 for document delivery and interlibrary loan. So basically you're intended to be able to show it to people, use the preservation copy instead of the real one for all these times where you might want to copy it and give it to people. That includes on-site. the on-site provision's actually been improved. Previously, the old ones used to talk about a dumb terminal, which meant a terminal where people couldn't copy it off. So it was supposed to not be connected to a printer and not have USB and all this kind of thing. But of course, most institutions did not keep themselves a special dumb terminal for people coming in to look at their preservation copies. So what they've done is that they've changed that to reasonable steps to prevent infringement. We'll probably put together some kind of notice that people can use to say that, but for the time being, sort of reasonable steps can probably just be reminding them not to infringe copyright, that kind of thing. You can also potentially use the preservation copies, put them up online. However, the important thing to remember here is that you do have to do a whole separate test under Section 200AB about whether or not you can put them online. So Section 200AB is flexible. It lets you put things like orphan works and stuff up online, basically materials that where it's not harming the copyright owner, you should be able to put it up online. So you can use the preservation copies to do that as well, but you have to do a separate assessment as to whether or not you're allowed to do it under Section 200AB. So that's the main messaging here. I see we have, can we preserve a local limited published book in a digital copy and make that copy available through the catalogue? I think you almost certainly can. You can preserve anything. So you can preserve a non-local, non-limited published book, but you can certainly preserve a local limited published book into a digital copy. That's what the preservation things are all about, turning things digital, basically. And I would say that if it's a local limited edition published book that isn't commercially available anymore or is difficult to get hold of, then you can probably make it available under Section 200AB. So basically the preservation copying lets you turn it into a digital copy straight away, no problem, no questions asked. And then you just have to make an assessment under Section 200AB, the flexible dealing exception, as to whether or not it's basically reasonable for you to make it available. And as long as you're not competing commercially with the market, you probably can. So if it's out of print or if it's just, hard to get hold of, that kind of thing. So basically, the new preservation laws are awesome. They allow you to do pretty much anything and do global best practice. And the only caveat, that whole commercial availability thing, is about not doing replacement copies. That's why it's in there. Rights holders were worried that libraries would basically say, oh, this book is looking a bit dog-eared, I will photocopy it instead of put the photocopies up. Or probably more relevantly, do that with electronic works. But of course, we know that that's not the point of preservation. That's not what people do. So you're basically totally fine to copy things into preservation formats. Just if you want to do a replacement copy, do purchase it. That's the basic message here. So as well, as I said, there was preservation and others. There are two other exceptions that were in the Act previously but had been hidden away a bit that they've pulled out to make it more obvious now. So one is a research exception for on-site research for original materials. So that's just letting you guys, staff members, and also people who come in on-site, they want to copy things for research, they want to communicate them, send them around for research. That's fine, that's allowed. It's basically, you can treat them the same way as you treat somebody in Section 49. Document delivery to clients, you can do that for people who come on site as well, is the basic idea. But the other one is much more exciting. It's an administrative copying provision. You always had it, but people didn't really seem aware of it and didn't take advantage of it. And it will let you do things like reporting. Anytime you have to copy stuff to report to government, anytime you're copying things for the purpose of cataloguing, things like thumbnails in the catalogue, particularly for images, I think totally justified under this one. Backing up, those kind of things. Anything that you're kind of doing for internal management, administrative purposes that isn't preservation and isn't client supply, basically probably covered by this. It's really broad and has no limitations at all, commercial availability, etc. So be very aware that you do have that flexibility to, now you can basically do anything you want for preservation as long as it isn't commercially available in the preservation format. You can do almost basically anything you want for administration, and in terms of access, you can do document supply into library loan easily, but you just have to, anything like putting it online, full digitization that includes online access, basically you just have to make an assessment under Section 200AB, whether or not that's allowed. So you've really got a lot of flexibility now to do, hopefully, and also anything you want to do in exhibition, hopefully covered by Section 200AB, particularly when you're working with orphan or rare works. you're going to be really well covered now. It's great. So the last one, and I am taking longer than I said I always do, is that I want to talk about is possibly the most exciting one, but apparently nobody else cares but us, but we really care. And that's changed to the copyright term. Now, I'm sure at least some of you participated in or were part of Cooking for Copyright. A few years ago, basically, librarians around Australia got together, the National State Libraries found recipes in their collections that were in diaries and letters, so unpublished recipes, published them up online and encouraged people to cook from them and take photos from them in a day of mass civil disobedience to protest the fact that unpublished works have perpetual copyright in Australia. So essentially, the unpublished works, so things like Captain Cook's diaries and Jane Austen's letters here at the National Library, where I'm based, basically they're still in copyright, even though they're hundreds of years old, hundreds of years since somebody died. Because of this quirk of perpetual copyright law, they were still covered by copyright, indefinitely. And indefinite copyright just makes no sense at all. The idea with copyright is that there's restrictions, but you can always get permission. But of course, once you get past, say, 150 years, the idea of finding the person who still has rights of the material to get permission is practically impossible for 99.9. Honestly, after 5 years, it's impossible for 99.9%. But certainly for unpublished letters and diaries and things like that, it's very difficult. So that's why basically Cooking for Copyright was a really effective way of highlighting the ridiculousness of this. The fact that all these recipes were still covered by copyright, hundreds of years later. And this is where the carrot marmalade comes in. Captain Cook's diary had carrot marmalade in them. The people were making Captain Cook's carrot marmalade. Apparently it's actually very hard. It ends up very saucy. Nobody seemed to have a lot of success. But, Captain Cook was, he was very big on anti-scurvy measures. It was one of the things that made him a bit of a game changer in exploration. So yay him. Anyway, so that's where the marmalade comes in. And the reason why we're celebrating with marmalade is because it worked. Basically, Cooking for Copyright, I really honestly think is largely responsible for the fact that the perpetual copyright laws were removed by this act. And better yet, we did a better job than everybody else. Canada and the UK have both removed theirs. And a lot of other countries still have them, but basically there's a global move towards ending perpetual copyright. But Canada and the UK did fairly bureaucratic things that involve registrations or 20-year delays. And our public servants just went ahead and fixed them in a really good, sensible way that is great. So again, another reason why this bill is really wonderful. So what they did is they just basically took out the special provisions for unpublished works and aligned the copyright with published works. So now for most works, which is literary and books, books, scripts, artwork, compositions, things like that. So they're the main works. It will be the life of the author plus 70 years. For subject matter other than works, so that's films and sound recordings, it's 70 years from creation. And that's the same now whether the work is published or unpublished. No difference. So home movie is the same as the latest Hollywood blockbuster. A letter is the same as the latest Harry Potter. But what's really clever about this, so it's nice and simple, and that comes into force in 18 months. There's delay till 1 January 2019, and that's to give a chance for copyright owners to publish their material if they want to get the longer term. And that's from some provision, some transition provisions, basically say anything published before 1 January 2019, you'll get 70 years from when it's published. And that's just a bit of transition. But as well as the fixing perpetual copyright, they also put in this cunning little thing that is a partial response to orphan works. It's partial orphan work solution, which is really great. So I'm sure you all know orphan works are works where you can't find the copyright owner at all, you don't know who they are, or you can't locate them or get in contact with them. And from now on, if there's a work that you don't know who the author is, so basically you can't work out when they died. So for work, it's life of the author plus 70. If you don't know who the author is, it will be 70 years from when it was created or from when it was made public, if it's been made public. So it's a really big deal now that orphan works will have a finite term. Instead of looking at this, at this letter from the early, 19th century and saying, well, the guy could have died 1 year later, or he could have died 50 years later, and I just don't know, and so I don't know when this goes into public domain. You'll now be able to basically say, okay, when was this letter written? Has it ever been published in a book or online? No, it hasn't been published in a book or online as far as we can tell. We can't find any evidence of that. I should point out, you don't have to know definitively. In that case, it's 70 years from when that letter was written. And, that letter's more than 70 years old, so it's in the public domain. So it's really exciting and a big change. It doesn't solve all the orphan work problems. You're still going to have problems where orphan works where you know who the copyright owner is, but they just won't respond. And you'll still have that 70 years where you can't use them. But basically, after 70 years, orphan works will be, most orphan works will be fair game in the public domain. You can do whatever you want with them. So that's a really big change. So the big caveats, they're not caveats with this because it's all good, but the two uncertainties that we need to work out is we need to start working out as a sector what an unknown author is. So if you know John Smith, that's not going to be enough to make him anonymous, and pseudonymous is obviously, if you've got no name, that's fine. If you've got John Smith, that obviously isn't enough either. If you know John Smith who lived in Bowrals in the 40s, how hard do you have to look basically to try to get hold of them? I was talking to somebody from the Department of Communications last night, the person who actually wrote the legislation, and they were basically saying that they really did think that even knowing, unless you could get in contact with them, there's a very good chance, or unless you knew when they died or you could get in contact with them, there's a very good chance that will count as unknown author. The other uncertainty that we'll need to think about is when things have been made public. Again, she said very clearly it's supposed to be with the permission of the copyright owner. So even exceptions don't apply. So if a library or archive has done it, that's fine. That doesn't count as being made public. It's only if the copyright owner themselves has published it or put it up online. So that's really great. It's likely to be very limited circumstances. And again, it'll be like diligent search for orphan works. You don't have to prove a negative. You don't have to prove that it's definitely never been put up. You just have to prove that you can't find any evidence that it's been published. And hopefully most of the time that will only take 5 minutes because you guys are better at finding things than most people. So that's pretty good too. Most importantly is that they were very clear, the people from the department, that us as a sector should work this out because, as they put it informally, they put it as probably nobody else cares. We're probably the main people who are going to care exactly how these rules apply, and so it's just up to us to work out some norms. So I'll be working with NASLA and CORE. We'll work with all the major groups. We'll see if we can come up with some guidelines or something in the next year or so to help people feel more comfortable with these terms. But basically, hopefully, as of 1 January, we will have 1 January 2019, we will have not a few, not hundreds, not thousands, but millions of works fall into the public domain all at once, because basically every unpublished work, that's every thesis, every letter, every diary, that where the person died before 1949, or if you don't know who wrote it, where it was created before 1949, will fall into the public domain all at once. And even published material, if they're orphan works, if you don't know who created them, such as the wall posters here at the National Library, they don't have any signatures, they aren't necessarily owned by the Commonwealth, they'll all fall into the public domain too, if they're created before 1949. So it's really a great, huge pile of stuff's going to happen, and I encourage people to think of fun things we can do with it. Start looking at projects for materials in your own collections, or working with other institutions to do things like gififying things and, make use of this public domain material. So that's the really big change, and I really love it. There are 2 or 3 other smaller changes that have happened or are happening. Well, they are happening. They haven't passed yet. But we're nearly out of time, and I want to make sure there's still a bit of time for any extra questions. One is, for those who know about safe harbors, that's about whether or not that's about providing protection for you guys, particularly you as public libraries, for when your clients infringe copyright using your services. So if you've got internet access on site, or if you're running a some kind of collaborative project or, digital hub. At the moment, some people, commercial ISPs, have protection if their clients infringe copyright, but you guys as libraries and archives don't. The good news is the government, after a lot of lobbying, the government has agreed to extend the safe harbors to you guys as libraries, to educational institutions, and to the disability community. A bill's been tabled on that, and it has to go to committee, but hopefully it'll pass in probably the second quarter next year. There is one slight problem in that it doesn't actually go all the way to online service providers, which is what we really want. So think platforms, Australian-based platforms, so people who run services like Facebook and YouTube, but in Australia there's groups like Redbubble and Envato. So we didn't get everything we want, but you guys are covered with the new legislation, so that's great, and it's almost certain to pass. It's, again, fairly non-controversial. And the other thing is that there's some draft regulations that are supposed to be passed, hopefully this week, in the next few days. I haven't seen the final version, of course, because we only saw the draft and we provided comments, but they provide new exceptions to break TPM, so that's digital locks on materials. So if you have a DVD and it has a digital lock on it and you want to break it, you're now going to be able to do that for every single library and archive exception, and for the educational statutory licenses, and students and researchers will even be able to do it for fair dealings. But the only caveat is that libraries and archives won't be able to do it under Section 200AB. So those extra uses you're doing, like putting material up online or using it in an exhibition, you can't breach the TPM for that. However, you can breach it for preservation purposes. So you can preserve materials, and once you've got a preservation copy, that's free of a TPM. So hopefully that will cover you most of the time. And then the last final exciting thing is that basically the government, the Productivity Commission, had recommended some major changes. The introduction of fair use, which we again strongly support, the ALCC, as we think that would be better than for Australia and for Australian libraries. And the Productivity Commission had recommended that and some other things, including some stuff with orphan works and contractual override. And the government has committed to do a review early next year, looking at those three. It should be the first quarter, maybe a little bit later, but probably just first quarter next year. There's going to be a giant review looking at the copyright exceptions, orphan works, contractual override, basically trying to fix a lot of the major problems with the Copyright Act. And we're going to include in that trying to fix things like Section 49 and 50, get rid of the complexities around them, make them simpler, make them apply the same to different materials. So next year is going to be another really big year for copyright, trying to get these changes through. Probably might take a couple of years before they actually become legislation, but there's a very good chance that we'll be able to, the kind of thing that we did for the preservation exceptions, we'll be able to do for the other exceptions in the Act. So big thumbs up here. We're looking forward to next year. Now, see, we have got one question about using a copyright declaration form for interlibrary load. That does not need to change. Very good question, because the draft regulations did look at the forms and whether or not they wanted changes, but having reached out to everybody, nobody came up with any changes they wanted, so they will be the same. Even with the new regulations, they should be pretty much the same. The one change that we did ask for with the regulations is, the notices you put next to your photocopiers, currently you have to make them A4 sized. We asked them if they could make that more flexible and just say you have to make them at minimum A4 size. It's weird because people have them A3 size and they're technically breaching the law. So a very minor thing like that. But the notices that you apply for Section 49 and Section 50 don't change at all. Let me see. Will the disclaimer we have about copyright that we place in our public photocopier need to change from 22 December? No. Once again, the wording is exactly the same. What you've got should be okay. The only difference will be if you had it bigger than A4, hopefully it will now not be illegal for you to do that. It's a very minor change, but it just will make it easier for some. We don't have to tell people exactly what they have to look like. But no, your photocopiers stay the same as well. And what are the best way for people to stay up to date with these changes? We have a website. I forgot to put it on my slides. We have a website, libcopyright.org.au. I'll write it in, copyright.org.au. It has fact sheets on it about copyright, and we'll be putting up a fact sheet about these changes and what they mean within the next week. It isn't up yet, but we'll put it up within this next week, or at least before the end of the year. Also, we'll be circulating information through groups like ALIA. Basically, and the future changes will also be publicised, that kind of thing. It'll mainly be through your organisations. We are also setting up a mailing list, though it doesn't exist yet, for our website, so that we can send you out information when things change. So we'll be setting that up. Have a look at our website and just try signing up, and I'll try to remember to send around. I'll try to publicise as much as possible that you can now join the mailing list to be updated on copyright changes. Now, we have user form record of copying under section 53B for multiple copying under statutory license. Is this still needed? So under the statutory license, I assume you mean for educational copying. I have to admit, I don't know section 53, which is why I'm getting the Copyright Act now. I might stop sharing so you guys don't have to watch me get up, because I know the Library and Archives exceptions quite well, and I don't know 53B. Are you sure? Maybe it's 51? Because there isn't a 53B or D. There's a 51B, which is preservation copying. It must be under the statutory license. And unfortunately, I am not the best person to ask about the statutory license. Everything that you're doing at the moment should, everything you're doing at the moment should stay the same. Yeah, maybe it's an outdated thing. The record of copying, though, I think there is actually there is a whole thing about you have to record that you've done the copying. Yes, and we will do our best to send a presentation. We'll send the presentation round. That's not a problem. Straight away. I'll share it with Ellen straight away, and she can send it to the whole group. Yes, I'm not sure about that record of copying under section 53B and D. There are some provisions about having to mark the copies that you make before you send them out. We're hoping to make them a bit easier. At the moment, they don't work very well in a digital environment, but that will be next year. It won't be this year. I am not so sure about what the record of copying could be, unfortunately. Sorry about that. It could be something you have internal, or it could be something old. Any other questions? There you go. We've only run 2 minutes over so far, and we started 5 minutes late, so that seems reasonable. Ellen, do you want to take over to say bye-bye?
I do. There is. And there was also one other question about a font size in a novel. And
I've missed that one. Oh, yes, here we go. If a customer wants the latest novel copied into 38 font, are we supposed to do that? You totally can do that if it is not available in large font. If they can't purchase it in large font, you can copy it into large font for them.
But there is a company that does the is it print how you want, read how you want? That they will basically print in a whole range of fonts. So that would make it that getting a commercial copy is probably easier and cheaper than doing it yourself. So it would be looking at those options. That's
right. And the fact that it's also, of course, always worth talking to Vision Australia or the Guide Dogs, or there's various groups who convert materials. We're actually looking about having a centralised catalogue that will show you all the converted materials in Australia, but that looks like it might take a few years. It's not going to be a quick and easy thing. But hopefully that'll happen eventually. But the existence of Read How You Want, who will do the conversion for you, does not stop you from legally being able to convert it. So you can do it yourself if you want, but it will often be cheaper and quicker to get them to do it. So you guys have to work out what your capacity is, basically. But yes, you can definitely legally, copyright is no barrier to you converting something into 38 font, as long as the customer can't just purchase it as 38 font straight away. So that's the good news. Really good. Oh, here we go. There you go.
That was a great session. Thank you so much. I really liked, on one slide you had don't be too conservative or risk averse, and I think that comes with a whole lot of what you were saying, is to keep that in mind with the copyright changes. I think it's really exciting having changes in terms too.
This is one of our this is something I talk about in another presentation I do, but it's a good message to take home, is that people often ask for risk elimination in copyright. They want an answer that says, yes, this is definitely legal in all circumstances. Unfortunately, copyright is never, ever written that way. So a good rule of thumb to remember is that the answer with copyright will only ever be probably. So never look for a yes, just look for a probably and feel comfortable with that is the main thing. Do your best, look at the risk management aspects, but also don't ask for a yes, just ask for a probably.
Okay, there's another question that's come up.
What about a reference copy that a customer can't borrow? Can they copy the whole work unchanged? Yes, if it is not commercially available, basically. So if they can't buy a copy of that book, they can copy the entire work. I would say also if they don't need the entire work, so if they only want one chapter of that book or a few pages, they can certainly convert the chapter or the few pages as well, even if it's commercially available. So the commercial availability test includes looking at the amount they need. So if they need the whole work, if they only need part of the work and you can't purchase that part of the work separately, then they don't have to buy the entire book just to get that work. So that's an important thing to know about commercial availability too. But yes, pretty much 90% of the time, if somebody has a vision or other disability that's stopping them from accessing a work, they should be able to do it. Unless they can buy it, they should just be able to do it. There's no other limitations at all. It's really great.
Okay, any more questions at this stage, just before, in case someone's madly typing away? I'll just give it kind of 30 seconds. Okay, if no more questions, yeah, thank you so much, Jessica. That was really great. Yeah, and thank you to all who've joined in this experiment. Yeah, and I look forward to seeing what everyone does with the changes to copyright. Thank you.
And thank you to everybody else. Lovely chatting.